Welcome to the Judicial Committee of the Privy Council. I'm sorry we've been somewhat delayed in starting this morning because of technical problems. We are beginning today a hearing expected to last 3 days of 2 appeals from the Channel Islands. One, an appeal from the Court of Appeal of Jersey, and the other from the related questions of law concerned essentially with the claims which trustees may have against trust assets to be indemnified or reimbursed for liabilities they've undertaken or costs they may have incurred as trustees. And how those claims are to be dealt with in situations where there are claims by present and former trustees and where the trust assets are insufficient to satisfy all the claims. I'm hearing this appeal with 6 of my colleagues because of its importance, and I'll introduce those colleagues now. Lord Briggs.
Good morning.
Lady Arden. Lord Stevens.
Good morning.
Lady Rose.
Good morning.
Sir Nicholas Patton.
Good morning.
And Sir David Richard.
Good morning.
I'll now invite counsel for the appellants in the Jersey appeal, Miss Warnock Smith, Queen's Counsel, to begin her submission.
Thank you, my lord, and good morning, my ladies and my lords. This is an appeal, as my Lord Reid has indicated, which raises all sorts of issues about the relationship between incumbent trustees and former trustees, they together with their beneficiaries and third-party creditors. In this appeal, I appear with Miss Stanley, Queen's Counsel, and also with Mr. Simon Hurry, Advocate Simon Hurry of the Jersey Bar, who is off camera, but nevertheless is here. You will have seen from the court circular that Advocate Damien James was due to appear with us, but in fact we have Advocate Hurry with us this morning. May I first explain that Miss Stanley and I propose to share the speaking between us. I will deal first with the overall picture and with certain specific trust law issues, in particular in relation to Jersey trusts. And then Miss Stanley will do what we've been calling a deep dive into the cases on trustee liens, which form really the foundation of the need to analyse where they take the panel. Then it will be back to me to deal with any outstanding points. With that background, I should also say that by agreement with the appellant in the Guernsey case, Mr. Machel QC, who is appearing for the appellant in the Guernsey case, who has adopted some of our arguments, and in a tit-for-tat arrangement, we have also adopted some of his arguments in order to avoid duplication, as the panel has urged us to do. So we will not be dealing wholly with the whole of our case, because we will be relying on Mr. Machel to deal with part of it, in particular the real nitty-gritty about priorities. But he, by the same token, will not need to deal with the whole of his case, because he will be adopting submissions that have been made in our written case and which we will now be making orally. So we hope by those means not to duplicate unnecessarily arguments and references to cases. Now, the appeal really, it seems to us, is about relationships. It's about relationships between former and successor trustees it's about relationships between trustees and their beneficiaries, and it's about relationships between trustees and creditors. And what it really requires is a sharp focus on the use of terminology. There is a lot of confusing terminology involved in an analysis of the cases. We see references to liens, charges, floating charges, non-possessory liens, and so on. And the object, we respectfully suggest, is for the panel to attempt to clarify the meaning of those expressions and their practical attributes and consequences. We have a lot of terminology to deal with, but what we really need to know is what they mean. What do they connote? What sort of rights are given by use of those expressions? One of the expressions that is frequently used is that of an insolvent trust. The issues before the panel today arise in the context of two likely insolvent trusts. But we venture to suggest that that too is a rather unhelpful term to apply, because although it's universally accepted that it's not accurate, that we're not talking about an entity which is insolvent, we are talking about a trust fund which has an insufficiency of assets to meet all the claims against it. And both the courts and advocates constantly reminded themselves that it is only a shorthand expression to use to describe that situation. We venture to suggest that it's not really very helpful as a shorthand expression, because it takes the focus off the need to analyse the relationships involved between the parties. It does give the suggestion, at least psychologically, that one is dealing here with some kind of corporate body or semi-corporate body, a notion that was rejected by the panel, by the committee in what we've been calling Investec 1, the previous decision of the Privy Council in Investec and Glenalla, in which the court analysed the effect of Section 32 of the Trust Jersey law and rejected the notion that it gave a trust in Jersey some kind of semi-corporate or corporate identity. So really it's clarification of terminology. Now the facts, the relevant facts for the purposes of this appeal, I think can be shortly summarised. They're shortly summarised in the respective written cases, but for the purposes of today, I think all we need really is that the trust in question in the Jersey appeal was settled in 2004 by the mother of the appellant in the Jersey appeal, whose executor, she having died subsequently, is the appellant, is the executor. And the former trustee, the respondent trustee, Equity Trust Jersey Ltd, was the trustee of that trust, the original trustee, and was the trustee for a comparatively short time until 2016, when it retired at the invitation of the settlor and entered into a deed of retirement and appointment in a conventional form. And I'll take the panel, if I may, to the terms of that deed fairly shortly. It is, we submit, an important document in the context of the Jersey appeal, because what we say is that whatever rights the former trustee had, might have had at law, as a matter of Jersey law, those rights were affected by and effectively replaced by the terms of the contractual agreement that it entered into at that time. So it is an important document. It's also an important document not only in the particular circumstances of this case, but because of the frequency with which such documents which such contracts are entered into. It is very conventional indeed for retiring trustees and new trustees to contract between themselves to regulate their relationship for the future, protect the outgoing trustee, to provide security for the outgoing trustee if that is appropriate, and to allow the incoming trustee to carry out its role as trustee properly, knowing exactly what sort of exposure it has to the former trustee. So that there is both a specific point on the facts of this case and a more general practical point, which it's important to clarify, both for the clients in this case and for trust law practitioners and their clients more generally. Now, may I take you first to the Jersey judgment on the application for leave to appeal in this case, and it appears at pages 455 to 458 of the bundle. And this was the unanimous judgment of the Jersey bailiff, but then Jersey bailiff Sir William Balash, John Martin QC, who was one of the Jersey appeal court judges in that case, and Sir Michael Burt, who was the former bailiff of Jersey. So it's a powerful court with substantial Jersey representation on it. As we'll see from paragraph 3, the court gave unconditional leave to the appellant to appeal from the judgment of the substantive judgment of the Jersey Court of Appeal. And they explain in paragraphs 5 and 6 what the arguable points of general public importance are. And they explain that they consider that the first is the correct method of dealing with the liabilities of a trust whose assets are insufficient to meet the claims on it. Although such cases are still rare, when they do arise, they cause practical and conceptual problems that are novel. There's no authority in this jurisdiction, in England or elsewhere, apart from our decision that deals directly with the issues. We think the pointers of general importance to this jurisdiction more widely. The second point is the status of a trustee's lien in Jersey law. The Judicial Committee's conclusion in Investec and Glenalla in 2019, at paragraph 59, that the existence of a trustee's non-possessory lien securing his right of indemnity was one of the principles of English law that must be regarded as having been part of the law of Jersey prior to the enactment of the Trust Jersey law, was fundamental to this court's decision. But as both the bailiff and Justice of Appeal John Martin pointed out, a non-possessory lien was on the face of it not something that was recognised by Jersey customary law. Further consideration of this issue is of general public importance to Jersey, in particular because of the necessity to uphold the island's customs and to recognise the separate origins of its law. And I will, of course, take you to all the judgments in the Jersey Court of Appeal in due course, but there was a unanimous agreement there that these were matters not merely of importance in the particular circumstances, but more generally. I should emphasise too that the second point, the status of a trustee's lien in Jersey law, is not simply a question that arises in the case of an insufficiency of assets of the trust. It is a much more general point and involves a survey of a wide range of material. Paragraph 6 to the court went on to say that we consider that both these issues need to be considered by the Judicial Committee at this time. It's important that the proper way of dealing with trusts where there's a deficiency of assets should be established sooner rather than later, so that present creditors can know where they stand and future creditors can decide on what terms to deal with trustees. I interject to say also, although it's not said in that paragraph, of course, it's important for trustees and their successors to know what the answers are to these questions. It's not simply, because it's not simply a question that arises in the case of an insufficiency of assets, it's extremely important to the trustees themselves to know what sort of rights arise out of the supposed non-possessory lien that is said to exist. Then at paragraph 8, I should just mention paragraph 8, we make clear that in identifying these two issues, we do not intend to confine the leave to appeal to those issues. If the executor has other points it may properly raise before the judicial committee, it is at liberty to do so. That applies in particular to the issue raised by the appeal in relation to the recoverable costs judgment, the two judgments that are relevant to this appeal, which is closely related to the first of the issues we've identified. So there's the court recognising that other issues may have to be resolved in the course of resolving those two primary issues. And I should mention at this point that it is argued against us by the respondent that somehow we don't have leave to raise the point about the deed of appointment and retirement that we now hope to pursue. That is to say, our point that effectively, in the circumstances of this case, and perhaps more generally, it replaces any rights that a former trustee may have had. We do submit that given the width of the unconditional leave to appeal that was given by the court, that is a proper point to raise, and the committee has helpfully indicated that it will hear our argument on that point de bene esse and see where that takes us. But we do say that, first of all, we have leave, and secondly, that it is directly relevant to the question, what is the nature of a trustee's lien, what are its attributes, when does it come to an end, how long does it last, and so on. It's very difficult too, in practical terms, to talk about the retirement and appointment of trustees without recognising the practical reality, the everyday reality, that trustees almost always, certainly in cases of voluntary retirements, such as we have in the Jersey case, will enter into documents of this kind. And it's accordingly an extremely important point that we say. Now, before taking you through the judgments below, I wonder if I could set this in context by looking at, first of all, the relevant terms of the trust in question. There are very few of them. The relevant provisions of the Trust Jersey law, both as it stood at the date when the respondent retired trust, and as it was subsequently amended, second is a very short. But if I could take you first to the terms of the trust, it's bundled pages 459 onward. And there are, I think, only 4 provisions. Sorry, I've been covering my microphone. I hope I can be heard. I'm grateful.
Yes, we've heard you.
Thank you. Yes, 459 on, but there are, I think, only 4 provisions of the trust itself, which is otherwise a conventional Jersey law discretionary settlement of the type that was commonly seen around about 2004. Of course, these standard forms change with time, but there is nothing, I think, unusual for its time in this particular trust. And I think I need only to show the panel clause 16E, which is on page 476 bundle. Clause 16 deals with the mechanics of the earlier subclauses of clause 16 deals with the mechanics of the appointment of new or additional trustees, how that happens, what needs to happen in order to effect a removal. perhaps I should also look at clause D. Acts and deeds done or executed for proper vesting of the trust fund in new or additional or continuing trustees shall be done or executed by the continuing or retiring trustee at the expense of the income and capital of the trust fund. And then E, an outgoing trustee who is or may be liable as a trustee hereof or as a former trustee, either for any taxes of whatever nature and whether enforceable or not, or any other liability, whether existing, future, contingent or otherwise, shall not be under any duty to transfer the trust fund unless reasonable security is provided for such outgoing trustee against such liability, including, without prejudice to the generality of the foregoing, an indemnity from any new or a continuing trustee in substantially similar terms to any indemnity which the outgoing trustee may have given to any former or continuing trustee upon such outgoing trustee being appointed. So the outgoing trustee, as he's referred to in this case, is not, according to the trust, obliged part of the trust property unless reasonable security is provided, and that is against any liability, including indemnities from the new or continuing trustees can also be given in relation to so-called chain indemnities, that is to say, indemnities which an outgoing trustee has itself given to former trustees. The panel will know that very often, of course, one has a succession of trustees in a long-running trust, and the pattern is generally that an outgoing trustee will require an indemnity from the former trustee when that second trustee retires. Then there will be a further indemnity given to the new and incoming trustee, and so it goes on down the chain. So those are generally referred to as chain indemnities. So there's the power of an outgoing trustee to require that indemnity. There is then clause 18, which is on page 478, and that deals with the position of outgoing trustees generally. And that contains in subclause 18A a release from liability for an outgoing trustee. So a trustee ceases to be a trustee for any reason, and in the case of a corporate trustee, all of its officers or employees, heirs, assigns, personal representatives in the states, are released from liability to any beneficiary, trustee or other person interested under the settlement or any act or omission in relation to the trust fund, except A, 1 and 2, liability in respect of breach of trust arising out of fraud, willful misconduct or gross negligence, which no release can be given, and any liability in respect of act to recover property still in the hands of an outgoing trustee, but otherwise there's a general release there. Then in B, there's a repetition effectively of the entitlement to be indemnified out of the trust fund in relation to obligations or liabilities which it may have incurred as a trustee, which he may be liable as a former trustee, and for which he would have been entitled to an indemnity out of the trust fund had he still been a trustee. In other words, not breaches of trust caused by fraud, willful default, or gross negligence, none of which can be excluded as a matter of Jersey law. And then a trustee who ceases to be a trustee may require to be provided with reasonable security for liabilities before surrendering the whole or part of the trust fund. My Lord Briggs, I see, has a question.
Will you be coming in due course to explain how in your submission the release in clause 18A works in relation to a liability incurred by a trustee before retirement to an external creditor?
Yes, my Lord, certainly. And
I won't trouble you now if you're going to deal with it in due course.
I'll certainly deal with it in due course, but it may be useful, my Lord, just to say at this point, you'll note the wording in 18A. It's a release from liability to any beneficiary, trustee or other person interested under this settlement. It's very broad language.
Yes.
Now, whether one refers to a creditor as being interested under the settlement, in part depends on the question of what is the nature of a creditor's interest in the trust fund. So this may be premature to discuss that particular point here, but I certainly will be coming back to that. Thank you for that, Sarah. And then, so a certain amount of overlap between clause 18 and clause 16, which we saw earlier, but not inconsistently so. And then clause 19 clause 19 again contains the effectively the exoneration provision that the trustee, none of its officers or employees is liable for any loss of trust fund unless those caused by fraud, willful default, or gross negligence. And then I think the only other provision that I need to show panel is over on page 494. So we've looked at the power of an outgoing trustee to require security and to obtain indemnities. This is the matching power of the incoming trustee to give warranties and indemnities of the kind which an outgoing trustee would expect to be entitled. And this simply gives this paragraph 16 of the first schedule of the trust, gives the power to enter into any warranty or indemnity in favour of the former trustee in respect of taxation or other liability, whether of the fiscal nature or not, and whether existing, future or contingent, and so on, similar sort of wording, and to charge or deposit the whole or any part of the trust fund as security for such warranty, and further alternatively such indemnity in such manner in all respects they should think fit. That's important because often the question for incoming trustees, the new trustees, is do we have a power to give indemnities to a former trustee, and are we exercising those powers reasonably by doing so? And that is often part of the bargaining that goes on between the parties, former trustee, new trustee coming into office, the terms of the indemnity that should be given, which has to be reasonable from the point of view of the new trustee taking care of the interests of the beneficiaries, but sufficient to protect the outgoing trustee. So it's important to have identified the power for the new trustee to be able to do that. So those, I think, are the relevant provisions of the trust. As I say, otherwise it's a perfectly conventional discretionary trust. The next thing I think to show you are the relevant provisions of the Trust Jersey law at the time of the retirement. And I hope the panel all has access to the supplemental authorities bundle that was filed recently. The first item of which it's at starts at page 1 of the supplemental authorities bundle is the 2004 version of the Trust Jersey law. The reason it's gone into a supplemental bundle is that only one of the provisions of that law was included in the original bundle, and what we wanted really was to show you the entirety of the laws it stood at that date. I'm hoping that that's not causing difficulty to have access to it. I'm grateful. So there are several provisions I think it's worth noting in the Trust Jersey law. As I say, this was the version in force from 31st August 2004, and you'll recall that the retirement of the trustee took place in 2006. So this was the version then current. And if I could draw your attention to several of the provisions. First of all, Article 11, which is on page 11 of the Supplemental Authorities Bundle, and it's Article 11.2, which provides that subject to Article 12, which is irrelevant for these purposes, it's about trusts for non-charitable purposes. A trust will be invalid to the extent, one, that it purports to do anything, the doing of which is contrary to the law of Jersey. Two, it purports to confer any right or power or impose any obligation, the exercise or carrying out of which is contrary to the law of Jersey. Now that may prove to be relevant to this appeal, because what we say is that as a matter of Jersey law did not then and does not now recognise such an animal as a non-possessory lien. If that means, if that expression connotes some sort of security interest over the assets of the trust. So Article 11.2 might well be in play in terms of the effect of the rest of the Trust Jersey law on the existence or otherwise the enforceability, existence and enforceability of that sort of right, since that is what is relied upon by the respondent. Respondent's case is essentially that it is the existence of a non-possessory lien known to Jersey law that gives it the rights of priority over successor trustees and their creditors, which, in our submission, is unattractively claimed by equity trusts, the former trustee. We say Jersey law does not recognise that, and there's nothing in the Trust Jersey law that would validate the imposition of any right which is not otherwise known to Jersey law. Then Article 19 deals with the resignation or removal of a trustee. It was a resignation in the case of the Jersey appeal. And Article 19.4 provides that a trustee shall cease to be a trustee of the trust immediately upon the trustee's removal from office by the court or the trustee's resignation becoming effective. And B, I think, is relevant for these purposes. And then in 5, the person who ceases to be a trustee under this article shall concur in exercising all documents necessary for the vesting of the trust property in new or continuing trustees. That is necessary as a matter of Jersey law, because Jersey law does not contain the automatic vesting provisions that are contained in the English Trustee Act and other statutes, so that what is required from an outgoing Jersey trustee is active participation in a vesting of the assets in the new trustee. The reference in Article 19.4 to the 4B, to the trustee's resignation becoming effective, it is why deeds of, or I should say, because this is the expression used in Jersey, instruments of appointment and retirement are generally negotiated before the trustee's resignation becomes effective, for obvious reasons, because the trustee ceases to be a trustee at that point. And so you effectively you refuse to resign until you've got what you want in terms of indemnity and security. Then in Article 26, which is on page 17, that is the general right of reimbursement of trustees. 26.2, a trustee may reimburse himself or herself out of the trust or pay out of the trust all expenses and liabilities reasonably incurred in connection with the trust. So there's an express right of reimbursement. Section 32, which the Judicial Committee considered in detail in the Investec and Granada decision, is at page 19 of the bundle, and this is the provision which was held by the, in that, or the advice in that case, was held to protect a trustee contracting with someone who knew it's a trustee, protect such a trustee from personal liability, because, as it's known, trustees contract generally in their own personal right, unless they contract otherwise, for some kind of direct recourse to the trust fund, but in general, trustees are contracting as themselves, and Section 32 was designed to protect. So the committee held in Investigating Glenalla, in our submission, to protect a trustee from personal liability. Otherwise, if the creditor does not know that he's contracting with a trustee, then full exposure to personal liability. But the effect of Section 32 is really not an issue in our submission in this case. That was decided by the Investigating Glenalla. It rejected the idea that Section 32 gave some kind of semi-corporate system to a trust, recognising that the trust, as I said at the beginning, is all about relationship, not about a corporate system. Then in Article 34, again, position of outgoing trustee, and this largely echoes what you have already seen in the trust itself. There's nothing in the trust which is inconsistent with the provisions of Section 34. Article 34. Article 34(1), subject to paragraph 2, when a trustee resigns, retires, or is removed, he or she shall duly surrender trust property in his or her possession or under his or her control. So obliged to hand it over as a basic proposition. But a trustee, in 2, a trustee resigns, retires, or is removed may require to be provided with reasonable security liabilities, whether existing, contingent, or otherwise, before surrendering trust property. Hold on to office until you've got what I put it earlier on. But there is a positive obligation to surrender trust property, subject to requiring reasonable security. And when we look at the DORA, what we will see is the deed of appointment and retirement. And what we will see is that equity trusts expressly acknowledge that the terms of that document, that agreement, provided reasonable security to it. So it was then obliged to surrender the trust property. And what the long and short really of what we say about that is, and that's the end of it. What happened was that whatever right the outgoing trustee might have had at common law, the whole terms of what it agreed govern the future conduct of its relationship with the new trustee and its successors, and that really is the end of the story so far as this particular case is concerned. Then we, in Article 34(3), we get the same provision as we saw in the trust, about which Lord Grace asked. A trustee who retires or is removed and has complied with paragraph 1, he's handed over the property, shall be released from liability to any beneficiary, trustee, or person interested. Again, that rather self there for any act or omission except liability for breach of trust or to recover trust property. So that directly that is directly mirrored in the provision of trust itself. But then, so that was the Article 34(2), which is really what governed at the time of the retirement the relationship between the parties. The law has been slightly altered since then, but not effectively in any material sense. It now appears, that provision now appears, as you'll see in a moment, in the revised version of the trust or elsewhere in Article 43A, but it's to the same effect. But at this time, it was 34.2 that really governed the. Then Article 43, before it was amended to insert 43A, again, that dealt at that stage with the termination of a Jersey trust. Now, we're not concerned here with the termination of the trust. The trust continues, albeit in a probably insolvent manner, but it does continue, so we're not directly concerned with that provision. But it's worth noting that Article 43.2 also contains the same sort of mirror provision about being able to require reasonable security for a party with trust property. And what we really say about that, we can come to this in more detail, but what we say about that is it's Jersey's solution to the problem about what happens to a former trustee's right. What it's entitled to do is to protect itself by obtaining security, then it's part of the trust property, that there is no then continuing right other than the right of indemnity. And this is where it's important to be clear about terminology, not, we say, the right of a lien, the property, but a continuing right of indemnity in relation to liabilities properly incurred. But all that will be dealt with in the deed of appointment and retirement of the party.
Can I just ask you just a question about the interpretation of paragraph 2? Who liabilities of whom to whom?
My Lord Reid is talking about Article 34.2.
43.2.
Yeah, 43.2 is effectively the same in the case of a termination of the trust rather than simply a change of trusteeship. It's the same idea. So reasonable security for liabilities, whether existing, future, contingent or otherwise, force rendering trust property. That is a reference to proper trust liabilities. In other words, liabilities that are incurred both reasonably, that is to say, they were proper for a trustee to incur and they were reasonable in amount, and were not incurred by a trustee who was guilty of fraud, willful default, or gross negligence.
Yes. So this is on practice. Is security for liabilities, meaning security for the trustee's right to be indemnified against his own liabilities to third parties?
Yes, my lord. Those are proper trust liabilities, and I think it is important to stress in this case that we are only talking here about the right of recovery. When we talk about the right of indemnity or the right of reimbursement, we're talking about the right of a trustee to be reimbursed for having incurred or being entitled to have recourse to the trust fund if they're incumbent. The right of a trustee to be indemnified against liabilities to third parties, its own liability, its own costs and expenses and fees and so on, the whole range of possibilities might arise. But they've all got to be, in order to be recoverable at all, reasonable, as I say, in both in nature and amount, and not incurred by reason of breach of trust for which the trustee is not exonerated. And of course, we are urged in this particular case, strained. I'm sorry, Lord Briggs also has a question.
Yes, if Lord Reid's finished his question.
Yes.
Can I come back to my question? Now we see it in Article 34.3. The release which occurs under 34.3 is only in respect of liabilities to a beneficiary, trustee or person interested under the trust. That presumably doesn't release the outgoing trustee from liabilities to third-party creditors, and therefore presumably under 43 2, that will be something of which a former trustee can avail himself in relation to that class of liabilities from which he won't have been released.
Yes, I think that's right, my Lord. The reference of persons interested under the trust seems an inappropriate expression to use in relation to third-party creditors. I mean, they might be interested under the trustee's trustee's right of indemnity, but that's not quite the same thing as being interested under the trust. So I think probably it's there, and I'm speculating here, but I think it's probably there because somebody may become interested in under the trust while not being a beneficiary. I'm thinking, for example, of, let's say, the trustees exercise their power of appointment or advancement by exercising it in favour of somebody who is a beneficiary, but by benefiting someone else. That is to say, an advancement, for example, to X, who is a beneficiary, by creating new trusts to settle the advance, let's say, under which his own wife and children become interested. And they would then become, probably, I suggest, persons interested under the trust indirectly, while not falling within the strict definition of beneficiaries. I think that's all it's intended to say.
Yes. So in broad terms, is paragraph 2 concerned essentially with liabilities incurred in the course of properly administering the trust, whereas 3 is concerned with liabilities arising from a breach of trust or some other sort of breach of a duty as trustee?
Yes, my lord, I think that's exactly right. That's how it works. It matches with the exoneration provision.
Yeah.
So of course, just thinking about the position of creditors further for a moment. So what ordinarily happens if there are known third-party creditors, and is what happened in this particular case, is that liabilities are novated to the incoming trustee. So the outgoing trustee gets his release in that way by being let off the hook, as it were, of liability to third-party creditors, because it's the new trustee which expressly takes on the liability. That's again why a contractual arrangement on a retirement is so important to an outgoing trustee, because in the ordinary course of events will want a formal release from direct liability to third party. Then I think I should, yes, I'd like to draw panel's attention to Article 51. This is on a different point, really, but it's a point that will arise on, I think it's called our third alternative argument, that is to say, the width of the Jersey Court powers to fashion a scheme in order to administer a trust where there is an insufficiency of assets. It's convenient while we have the act open to look at it, the law open. And it's a very wide power. It's Article 51 on page 26. First of all, in subparagraph 1, the trustee can apply to court for direction concerning the manner in which the trustee may or should act as general supervisory jurisdiction of the court, such as recognise it in England and also other jurisdictions. Then 2, the court may, if it thinks fit, make an order concerning the execution or the administration of any trust, and do various other things. When we come to that third alternative argument, very much at the end of the submissions, I'll take you to a new case, a recent case in the Jersey Court just reported a few days ago, which stressed the width of the Jersey court supervisory jurisdiction under Article 51, which may go somewhat wider than the conventional supervisory jurisdiction of the court as recognised in other jurisdictions. But perhaps I could leave that aside for now, because that's very much a backup argument as far as we're concerned. Over the page to Article 54, that's at page 28. It's worth noting, it's difficult to know quite how far to take this point, but Article 54 is headed Nature of Trustee's Estate, Following Trust Property and Insolvency of Trustee. Note insolvency of trustee, not insufficiency of assets of trust fund. Subject to subsection 1, subject to paragraph 2, the interest of a trustee in the trust property is limited to that which is necessary for the proper performance of the trust, and such property shall not be deemed to form part of the trust asset. Now, when we come to look at what the nature of a trustee's interest in the trust fund is in relation to recovery under its indemnities, it may be necessary to look more closely at the terms of that trust. But it does that provision, but it does at least hint at the idea that the interest of a trustee in trust property is strictly limited to what it needs to recover in the way of reasonable reasonable outlay, reasonable liabilities, reasonable deferred liabilities, does not form part of the trustee's asset, so does not amount, probably say, to a full beneficial equitable interest in the trust property in some of the cases might hint. It is simply a right to recover what is needed to be recovered by the trustee in order to protect itself against reasonable liability. Take that point, if I may, a little. Yes, my Lord Pat.
Can you just on a very little point? I mean, is interest in that? I mean, I think you're addressing this on the basis that that refers to the trustee's equitable interest or equity, whatever form that may take. But is that not also including their legal ownership? I mean, of the trust assets? Is that not what it's primarily talking about? Because this is to protect the trust assets against a claim by the insolvent trustee's creditors.
Yes, I think that's its primary purpose, Lord. I agree with that. But when we're little a does at least, as I say, I suggest that after all, the trustee has the whole legal interest in the property. It has the whole ownership of property.
Yes.
But it's making it clear that while one says that, and that is the proposition of matter of law, the trustee's own interest of in relation to that trust property, it is limited to what it can recover by way of its property. That may matter in terms of subrogation. But it's certainly, as you rightly say, B, it's certainly aimed at protecting that part of protecting the trust fund against assets, save to the extent that interest be subrogated to the trustee's lien, if that's what it is.
The way, I don't know if this is at all helpful, but the way that this issue is conceptualized in Scots law is to say that the trust property is vested in the trustee, but it does not form part of the trustee's patrimony. In other words, it's not vested in him as his personal property, and therefore is not attachable by his personal credit. But it's vested in him sway trustee and attestable by creditors that he has in that capacity.
Yes, may I say respectfully, my lord, I think that is a very helpful way of expressing it, and I think that's exactly what Article 54 is trying to say in the time. But one can get some of the cases, and we'll see when we get to the cases. So some of the cases seem to go a little far, if I may suggest, in identifying for the trustee an equitable interest in the property for its own benefit, which may not be the suggestion that's implied in the provision. But when we get to the cases, I'll suggest that issue is solved. Subsection 4, just while we're on that section, of course, says where a trustee becomes insolvent, the trustee's creditors have no right or claim against the trust property, except to the extent that the trustee himself or herself has a claim against the trust or has a beneficial interest in the trust separately. Sometimes, of course, the trustee is a beneficiary of the trust, but not in. So that reinforces the separateness, as it were, of the trust assets from those of the beneficiaries. The trustee's rights of indemnity and the rights of any creditors be subrogated to those rights of indemnity. And then I think that is those are all the provisions that I'd like to take to. I just thought to draw attention to the next document in that supplemental bundle is the current version of trust law. There is only one provision there to show you. That is, well, two, sorry. Article 34 has now had its sub-article 2 plucked out of it and put into Article 43A, which is on page 63. You'll recall that Article 43 previously just dealt with termination of trust as opposed to ongoing trust, but still contained the same provisions about indemnity. Now appears in Article 43A, and it applies to a trustee who resigns, retires, is removed, or otherwise ceases to be a trustee. And in sub-article 2, sub-article 1A B, 1A 1B, may require to be provided with reasonable security. So it's the same provision. And then there's a new bit in sub-article 2 of 43A, which extends the protection to other persons than just the trustee. We saw in the trust that the right of indemnity was extended to trustees, directors and officers, so there was already an extension in this particular case to other persons. But now, as a matter of law, the right of indemnity can be extended to those involved, if I can put it in this general way, those involved in the administration of the trust, because these days, when I probably venture to say more or less correctly that most trustees are corporate entities rather than individual trustees, as in the old days, really the need is to protect its directors, officers, service providers, other people who are associated with the trust. So that's what Article 43 currently does. What it does not do, and this is what we'll come to in a minute, is to introduce any kind of concept of non-possessory fiat, albeit, show the panel, that was something that was being contemplated by the Jersey legislature as something that it might promote. The current state of the law does not include anything to do with non-possessory fiat. Now, at the beginning, my Lord Reed suggested that a break would be appropriate at time earlier than we've now reached. I wonder if you're still of that.
Yes, well, we were so delayed in starting that, speaking for myself, I'd be happy to carry on till 1 o'clock. But if any of my brethren or sisters wish to take a different view, then no, I think everybody's content to carry on. Thank you very much.
I'm very grateful. But I finished, I think, with the provisions of the Trust Jersey law, with which I would like to turn, if I may, to the provisions of the agreement that the parties made on the retirement of the initial trustee, and that is to be found starting at page 548 of the bundle. And it's called a deed, so quickly it should be an instrument, but there we are. And we've used the expression DORA because that tends to be the expression which is used universally in relation to kind of. I've seen Jersey documents referred to as IORAs, but that's rather more difficult to say. So if we could say with the DORA terminology are helpful and that's accurate in this particular case. So it was a deed dated 11th of October 2006, and it was made between the Setlaw Nouri and Equity Trust, the respondent in this case, and Bolaw Trustee Ltd, which was the incoming successor trustee. You will have seen from the statement of fact and the summaries in the various cases that there is now, in fact, a third trustee in Savile, but that needn't, and acting under the directions of the court, the Jersey court, but that I think needn't trouble us. The true relationship that we're concerned about at the moment is that between the original trustee and its successor. And I venture to suggest we should be looking at terms of this in some little detail, because it is it's what the commissioner, the learned commissioner in Jersey described as a reasonably ordinary DORA. Reasonably, I've forgotten exactly the expression you used to find it, but anyway, he said this reasonably conventional DORA. And it is a reasonably conventional DORA, except that it's to some extent unusually detailed. It's both standard form, Society of Trust State Practitioners recommended DORA form as of the time, but it's also got some highly specific provisions in it which dealt with the particular concerns of the parties at this time. So we have the recitals, and it recites the powers of the Setlaw as appointor to appoint new trustees. In E, the beneficiaries of the trust have requested that the retiring trustees resign from office, and the retiring trustees are willing to do that in consideration for certain releases and indemnities, including those contained. Then F, it's intended upon execution that the retiring trustees will, as soon as reasonably practical, transfer the assets of the trust. We've seen the provisions both of the trust and of the Trust Jersey law, which require that to happen once security is obtained. And certain particulars of the assets set out, specified in the first schedule. And both sets of trustees will enter into all documentation to assign, novate, or otherwise transfer the new trustees all the assets and liabilities and so on. So there's a plan for novation of liabilities, and then obligation to transfer documentation and so on. The specific reference at recital H to the provision requiring provision of information, and specifically that the retiring trustees would provide final accounts of the entities underlying the trust. There are a number of entities underlying the trust, property holding companies, investment entities, and so on, final accounts of the entities underlying the trust, and financial statements relating to the trust from 2006 to the date. So up-to-date accounts be provided, and certain other accounts. Provision for providing bank statements in relation to the trust in each underlying entity. And then K, the new trustees wish to release and indemnify the retiring trustees in the manner set out. Now, we then see in clause 1 a definition of the indemnified persons, which is an extended definition of retiring trustees. So it's to include respective officers and employees, and successors, personal representatives, estates, and so on, and such officers and employees in each of them. So it's an extended group of indemnified persons, which goes rather further than the requirements of the trustees. So the retiring trustees are getting some more out of this indemnity than it would have been entitled to under the provisions of the trust itself, and this being before the introduction of section 40, article 43A, which did make such a very wide extension that needed to be provided for expressly. Then we get the appointment in clause 2, trustees holding the property on the trust of the settlement. We've got the resignation from office in clause 4, and here, significantly, the provision mentioned to the panel earlier, the retiring trustees hereby acknowledge that reasonable security, inter alia, in the form of the releases and indemnities hereinafter contained, have been provided to them in respect to their trusteeship. Now, it's significant that there's reference to the releases and indemnities as being part of the security, so that the idea is not simply that security has to consist in physical security or ring-fenced assets or deposits, bank guarantees, something specific in that way. Security here is being used in a wider sense to incorporate the releases and indemnities themselves. And then the indemnity appears then in clause 4, subject to hereinafter provided, the new trustees hereby covenant with the retiring trustees for themselves and as trustees and agents for on behalf of each of the indemnified persons, that the new trustees will at all times hereafter release and indemnify and save harmless the indemnified persons and each of them from and against all and any actions, proceedings, costs, claims, and demands which may be brought or made in connection with the trust or in any way relating thereto, or to the trust funds, income, and so on, whether they're tax liabilities overpaid or not, or in respect of any property transferred to control of the trustees, and whether or not in respect of a period or event falling wholly or partly after or prior to the date hereof, and whether the same should be enforceable in law or not. So that's the widest possible form of relief and indemnity being given to the outgoing trustees, and that undoubtedly does refer to whatever the curiosity or the questions arising under the terms of the trust itself, as the release is provided under the trust and as trust Jersey law. Here is a comprehensive indemnity by which the trustees are releasing former trustees' liabilities and agreeing to indemnify the trustees against practically everything. I say practically everything because, of course, that comes with caveats, and the caveats come in the subsections of that, subclauses that, and these are conventional, so that's excluded from such indemnities any liability the indemnified persons in respect of which that person would not have been entitled to reimbursement or payment out of the trust fund. So it's only in relation to liabilities reasonably incurred, not incurred by reason of a breach of trust, caused by fraud, willful default, or gross negligence. So the trustee was not certainly agreeing to release the trustee from anything that kind. And then B and C, I think we needn't worry about too much. In subclause 2, we get the chain indemnity idea. That is to say, if the trustee, the new trustee, transfers assets either to a beneficiary by way of distribution or to new trustees as trustees of the trust fund, then what the new trustee must do is to require an indemnity to be given by the transferee in substantially the same terms as are given in this deed. And if they don't do that, then the new trustee is liable up to the amount transferred. In other words, because this is a liability, as we see in subclause 3, which is limited to the value of the trust fund from time to time, so it's limited to the trust funds in the possession or under control of the new trustees from time to time, you add back in any distribution or transfer to new trustees in relation to which the new trustee has not obtained this counter indemnity, chain indemnity from the new trustee. And that's why we go on having lots of successive indemnity to ensure that although everyone is exposed, both incumbent trustee and former trustee, to the vagaries, the value of the trust fund from time to time, because of course that's going to go up and down just in the ordinary course of events, ordinary course of investment, it is at least protected against a distribution or a transfer to new trustees which diminishes the value of the trust fund out of which the indemnity might. Then in subclause 4, we have a ring fencing, a specific form of security here. New trustees covenanting to establish and maintain a separate account of £2.5 million, and that's to be used for certain specified purposes, defraying outstanding liabilities to the creditors. So there's specific coverage for creditors listed in the first schedule, discharging of the VAT liability, discharging liabilities from third-party creditors already existing at the date of the deed, which are properly payable out of the trust fund, and so on. So we have that specific ring fencing, and then the amount can be released from that ring fence and as and when those liabilities are met and discharged. Clause 6 is significant because here the retiring trustees are giving the new trustees comfort about being told about any potential claim against the trust fund that is made against the retiring trustee. And it requires the retiring trustee to give notice to the new trustee of any claim can't come, and to allow the new trustee to take over conduct of the claim. Now, the panel will know from the summary of facts that the main claim in issue here is a claim by Equity Trust to reimburse an amount that it spent on compromising proceedings against 2 of its directors, or 2 directors of an underlying company, Angel Ltd, and against the trustee itself, vicarious liability for their action. That came about subsequent to its retirement. And the question there is, ultimately, is that a claim for which Equity can properly maintain its indemnity? That is to say, did it act properly in settling that claim? Did it, in fact, act in accordance with provisions of Section 6 by giving notice of any proposed compromise to the least the indications are that not the agreement is compromising that claim, but those will be matters to be dealt with at a later stage. Because we'll be aware that proceedings have taken place on the basis of an initially agreed assumption, and that has been adopted by the Court of First Instance and the Court of Appeal, an assumption that for the present purposes it's to be assumed that equity is entitled to be indemnified against that liability. Whether as a matter of fact in law that turns out to be the case remains very much to be seen. So we're proceeding on what may prove to be a false assumption, but it is nevertheless an assumption the court below were prepared to make. So we don't know whether that was caused by the trustee's own fraud, willful default, or gross negligence. We don't know whether that can be regarded as a reasonable expense for which reimbursement can be sought. But there were specific provisions there to keep the new trustee up to date with any late arriving claims and to allow, in certain circumstances, the new trustee to take over conduct of that claim. And then we get the time limit. Significantly, in clause 7, we get the time limit. I should have referred, when looking at the chain indemnity provision in subclause 2, clause 5.2, that after the expiration of 10 years from the date of the deed, the indemnity to be obtained from transferees only extends to liabilities in character of taxes and duties and other fiscal claims, and not anything else. So there's a 10-year limit there, and there's a 10-year limit here in relation to the ordinary indemnity, the general indemnity being given. And that, of course, would be entirely typical of a deed of this kind, an agreement of this kind, because part of the object of the exercise is to agree how the new trustees can properly administer the trust. How long does it have these claims, these potential claims, hanging over it? And in general, the accepted period tends to be either 6 years or 10 years, but it's a matter of negotiation in every case. And one of the difficulties about saying that somehow there is a lien, a right under a lien, which can trump, it appears, the express provisions of the deed of this kind, which limits the period during which such claims can be made, is an curious one, because there's never really been any convincing explanation by the respondents of how the two would live together. Or you would be conscious that the claim made by X is made both under the terms of the DORA and separate under a so-called equitable non-possession lien. Yes, my lord.
Is there an error? Is the two words "do not" at the beginning of the second line of clause 7 a typo?
Yes. So, well, your eagle eye fixes on exactly the drafting difficulty that applies to that particular provision. It puzzled me for a long time when I first saw it, because it seems to say that there isn't any time limit in relation to things which are not tax.
Yeah, quite.
I think it's badly put, but it doesn't match with the
No.
with the chain indemnity thing. I think it's effectively a misprint, I venture to suggest.
Well, that was my instinct. I'm glad to hear that you share it.
Yeah.
My other question is the 10-year period in some way linked to a relevant Jersey period of limitation?
Yes, I think that was probably the idea that tort claims could only come in after, within that period.
Am I thinking?
As I say, it's a negotiation always in individual circumstance. But I think that's the way it works. But it doesn't matter for practical terms in this case, because the claim came in from it within the 10-year period. So whether but it is
And if the claim comes in and is duly notified within the 10-year period, the fact it may take 50 years to litigate it out presumably doesn't trigger the disapplication of the indemnity.
No, I think not, my lord, because it's a claim under whatever indemnity you had at that stage, not a claim under the fire, as it were, which this did. But my point, but before your lordship's question, my point really was, and it's a central one to this appeal, is if there is something separate from the contractual indemnity that is negotiated between parties, nobody's ever really explained what its attributes are. How does it live with the express provisions that have been negotiated with the parties? Because it's said that it's the lien, the alleged lien, that gives rise to a priority, not the provisions under the DORA. Well, that's one set of allegations. It doesn't really explain how, what the tension is between the two, if they do coexist in some way, or one trumps the other. It's easy if the DORA trumps a lien, if one supposes that there is something. But the other way around, it's difficult to see how that can really work, because the parties carefully agree how the ongoing administration of the trust is to work. And that's often a very, very troubling set of negotiations. It's one of the most difficult aspects of trust administration that one can come across. But if you can then find that a former trustee turns up more than 10 years later, whatever, with a claim claiming a lien, I don't know how a trustee can work. Lady Rose.
Yes, there is a similar kind of thing in relation to a solicitor's equitable lien, which is regarded as waived if the solicitor takes a security from the client which is inconsistent in some way. Either it has a different interest rate or has different incidents, and there's considered to be an implied waiver by the solicitor of the equitable lien on taking the inconsistent express security.
Yes, thank you, my lady. That's extremely helpful analogy, and we say that's exactly what happened here. That this was an implied waiver. There isn't, I think, an expressness, but I think it's accepted, and was certainly accepted in the respondents' skeleton arguments below, that an implied waiver could certainly be effective in these circumstances. I think that your ladyship has exactly right. The analogy is right. So then clause 8, sorry to labour this, but it is important to identify exactly what provisions were agreed. Clause 8 is the provision for assignment, novation, transfer to the trustees of all the assets. And you will see, if you don't intend spending any time on it, if you flip forward to the lists of assets and so on, and to the provisions about providing accounts and so on, much was known. It's not everything was known about the situation of this trust. It's not a case in which there were some very general provisions about novating provisions, obligations, wondering whether liabilities would turn up later and so on. Very full information was provided in relation to the state of the trust, as of course one would hope, because after all it's the retiring trustee that has been administering the trust and should be on top of its financial state. So the agreement to novate, to provide accounts, to show liabilities, and so on, really, it really ought to, by virtue of this deed, really effectively drew a line under what was expected to be the liabilities of the trust, and they were to be dealt with all by the new trustee. And then I think that's it as far as the relevant provisions of the deed are concerned. Now, best
I'm sorry.
I want to make sure that I've left.
Can I just ask you?
I'm sorry, my lord.
Now, the clauses we were just looking at included provision for what were described as liabilities of the trust to be, well, I think the expression was assign or novate. And there are actually a lot of liabilities listed in Schedule 1. They're a bit difficult to read because they're printed sideways. Is there anything there that's relevant to us?
Not in the detail, my lord, at all. Merely that it was plain that the idea was that if there are any liabilities, they would be expressly novated. Yeah. Because one of the difficulties with novation is probably taking it out of course, but one of the difficulties with the analogy, or rather with the proposition that a previous trustee has this ongoing non-possessory lien, is that the fear is that creditors, third-party creditors, will be very unwilling to novate their liabilities to new trustees, because if what they're subsidiary to, as it were, is some kind of existing equitable interest or security interest in the trust property, that's not something that you would likely take on. And that's a point which I'll take you shortly to an article by a now retired bailiff, Michael Burt, commenting on the judgment below, in which he identifies that the precise point as being one of the difficulties in that analysis, because this is not all about protection of creditors. Is partially about protection of creditors. It's mostly about protection of trustees being able to secure services of good incoming trustees, and if what one has got is some sort of unregistered floating charge, as it's sometimes been described, over the trust fund, it's very difficult to see how any professional incoming trustee is going to be very happy about that concern, and that is one of the concerns, undoubtedly, to which the Court of Appeal, Jersey Court of Appeal's judgment gave rise.
Sorry, I'm only slightly tweaking your tail, but I mean, that doesn't seem to have been a problem in Guernsey, does it? Because they've expressly conferred that right on a trustee by statute.
Yes, they did. To me, extraordinarily, no, but yes, they did. As long ago as 2007 or 2008. But that's helpful, I think. I'm going to show you the Guernsey provision. That is quite helpful because Guernsey plainly considered that if it was going to introduce this sort of idea, it had to be done by statute. This wasn't something that it thought was part of the pre-existing law. And I'll take you, if I may, subsequently, we have time to the Jersey consultation papers on exactly the same point, where again the expectation is that Jersey would have to legislate for something if, as a matter of policy, it thought that this was a good idea. Personally, I think it's a very poor idea, but that's not, I don't make policy of the Jersey government or the Guernsey government. But it is odd. But Jersey has been considering this from as long ago as 2007, on the basis that Jersey doesn't have a well worked out idea about security in the shape of liens, let alone non-possessory liens in the shape of security, and that therefore it might be a good idea, and that they consulted on the subject, that it might be a good idea to introduce this in order to protect creditors in that way. Now, if a policy decision is made to that effect, that's one thing. But it still doesn't seem to me to get round the difficulty that a trustee incoming is going to find that extremely difficult. Borrowings generally are going to be extremely difficult at that idea. And if the government says that's a good idea, well, so
Yeah.
it's not something that arises naturally as a matter of the law, we say. Probably, I think perhaps the next thing is to consider, at least in some, in outline, because Ms. Stanley is going to deal with this in more detail when she considers the cases, but just to take a look at the Investec and Glenalla decision in order to demonstrate or to show you which bit of it, because it's not all of it by any means, is the part of it that has caused the trouble. And it's at starts at page 1580, 1580 of the bundle. Well, Briggs will no doubt remember this this case. He was one of the panel in the Investec Glenalla decision.
I remember being in it, but don't assume I remember every line of it.
No, of course not. It's a rather complicated decision. I wouldn't expect it. Fortunately, we're not going to have to ask the panel to trawl through this in any great detail, because it mainly concerns the effect of Section 32 of the Jersey law, and whether some sort of direct access to the trust assets had been created thereby for creditors, and the panel rejected that notion. Also made it clear that the right of recourse for creditors was through the trustee's right of indemnity and subrogation through the trustee's right of indemnity against trust property, none of which we have a quarrel with at all, although the grounds of appeal initially, or the notice of appeal originally raised that as a further question, on the back, I think, of what the bailiff had said in the Jersey Court of Appeal in the Jersey case, about a possible revisiting at some point of that idea. He floated the idea that maybe some sort of semi-corporate existence for a trust might be recognised in some way, but that is not something that we're pursuing. The part of the judgment which causes the difficulty is in the opinion of Lord Hodge, and it starts at the relevant part starts at paragraph 59 of the judgment. Well, sorry, I should say 57 judgment. Yes, it's page 1615. In paragraph 56, right at the end of that paragraph, well, perhaps the whole of that paragraph, actually, paragraph 57. And there he says, before addressing Article 32, some preliminary observations need to be made. Of course, there's an appeal in the Guernsey proceeding, not the Jersey proceedings, but the panel was considering Jersey law. Before addressing Article 32, some preliminary observations need to be made. The TDT, the trust in that case, was a discretionary trust established under the law of Jersey. in their modern form, trusts for creation of equity judges in England. There are, of course, concepts in other legal systems, notably in Roman law and in the civil law of France, which have some features in common with an English law trust, but they don't have the elaboration and detailed prescription which exists in a large and coherent body of case law that's given to the English trust law. The law of trusts in Jersey is a comparatively recent import from England. Its widespread use in the custody and management of wealth dates from the rise of a significant financial services industry in the 1960s. The international appeal of Jersey trusts is to a significant extent dependent on the certainty which derives from the English case law. Naturally, English trust law must be modified where it conflicts with established principles of Jersey customary law and has also been modified by Jersey statute. These general remarks apply equally to the trust law of Jersey. The Trust Jersey law is the principal indigenous source of Jersey trust law. It's not a complete code of the law of trust, but it gives statutory effect to some principles already well established in England and significantly modifies other principles. English trust law therefore serves as the background against which the provisions of the Trust Jersey law will be construed. And then paragraph 59. For this reason, it's necessary to start by setting out some well-established principles of English trust law, which are relevant to the present issue. And most of these are I think I've been reading in detail, but it's the passage at two passages at level 5 on the following page, page 1116, and little Roman 6 immediately underneath it. What he says at 5 is a trustee is entitled to procure debt properly incurred as trustee to be paid out of the trust estate, or if he pays it in the first instance in his own pocket, be indemnified out of the trust estate, that's Greek law. To secure his right of indemnity, the trustee has an equitable lien on the trust asset. Question Lewis there. But then he says, because an equitable lien does not depend on possession. Common law lien would depend on possession, but equitable lien does not depend on possession. Normally survives after he has to be deceased. And he quotes Henry Johnson in support of that proposition. Now, it's primarily the last line there that causes the difficulty, because an equitable lien does not depend on possession. Normally survives after he has ceased to be a trustee. Now, Reed Johnson is not, we say, authority for that proposition at all. It's better placed in the following paragraph, where it's used as authority for the proposition that creditors recourse against trust assets only by way of subrogation to the trustee's right of indemnity. We do say it's certainly authority for that proposition, but Stanley will look more closely at Reed Johnson in course. But it normally survives after he ceases to be a trustee. If one then goes over the page to what he says at the end of paragraph 59, the last sentence on page 1617 of his opinion, it appears to the board that all of these principles must be regarded as having been part of the law of Jersey or the enactment of the JL or its statutory. So he's finding, and indeed finding the board, that, or depending on the board, that applies to a matter of Jersey law as well as English law, and that is a proposition which we challenge if what he means by that, he meant by that sentence, is that it creates some sort of security right over the trust fund once the incumbent trustee is parted with the trust fund. That, we say, is not the law of Jersey, may not even be the general law of England. And those are the sort of cases that we're about. And position is, as we submit, that the customary law of Jersey does not recognise non-possessory liens, recognises now certain types of security, but only under the provisions of specific legislation requiring registration and various other formalities to be completed, not recognise a general non-possessory security. So that if that's what that means, that is to say that the former trustee does retain some sort of security interest over the assets, that cannot sit, we say, with the customary law of Jersey. Recent change of that legislation, still not the law of Jersey, not accepted. If, on the other hand, what that means is that the trustee has some sort of a beneficial interest in the property to the extent of its indemnity, there may not be the same inconsistency, in which case we would not need to invite this board to depart from that limited finding in investigative analysis. It's all to do really with, is this a security interest, or is this some sort of beneficial interest which survives, which prevails over the interest of beneficiaries, so as to allow the trustee to recoup expenses before the interest of beneficiaries recognised, indeed quantified, or is this a security interest that simply can't work as a matter of Jersey? Well, and that is something that Mr. Mitchell is also as well as dealing with security. So that's the bit of Investec and Flanella that causes the here, and it causes the issue here because in the Jersey Court of Appeal, the judgment of court with some powerful, three separate powerful judgments, and each of those judgments, but the judgment of the court in the Jersey Court of Appeal was that effectively they were bound by that finding of the board in Investec and Flanella, hold that was the matter of Jersey law position. But it does not appear that the board in Investec was taken to authority on those issues, those authorities that we need to explore further. So the extent to which we would want to ask this board, apart from that sentence of Investec and Flanella, will depend on the analysis of what the right actually is, or what is encompassed in that expression on possessory lien.
Did the remarks about equitable liens form part of the ratio of the decision?
Well, we say not. I mean, it may be that that's something that simply it doesn't figure in the real reasoning of the court, which is, as we say, to have dealt with the Section 32 point and rights of subrogation. The Guernsey Respondents written case suggests that there was a concession given by, I think, by Lord Goldsmith before the board in Investec and Flanella, that the trustee's right of indemnity is secured by a non-possessory equitable lien. So maybe it was based simply on that concession, but certainly there is no close analysis of the way in which this non-possessory lien is meant to arise as a matter of Jersey.
Yes, it's rather curious. Most of the authorities that Lord Hodge cites in paragraph 59 are Scottish. And he will have known perfectly well that equitable liens don't exist in Scotland.
Yes.
So I think he must have assumed that there was no established principle of Jersey customary law which would rule out the introduction of that aspect of English trust law into Jersey.
Yes, I think that's right, my lord. And if it was based on a concession, that reinforces that that proposition. Nobody, in other words, nobody told him otherwise.
Yeah, because I mean the only reasoning one can really find of it seems to be that was the introduction, was the intention was to introduce English trust law, albeit subject to modification insofar as it conflicted with Jersey customary law. Therefore, all these principles listed in paragraph 59, including 59.5, must be taken to be part of Jersey law.
Yes. Yes, well, I have two things to say to that. I think one that Jersey plainly recognised trust before, or the existence of trust before the introduction of the Trust Jersey law.
Yeah.
And to repeat really what's already been said, that
yeah.
nobody told him that Jersey customary law didn't allow that.
Yeah.
So he was assuming, as you say, that that's the position.
Yeah.
So it's all rather satisfactory, but it may, as you suggest, not be part of the ratio at all. It is simply a sort of scene setting account of certain principles before moving on to the major issues in that case, which were about whether a creditor could have direct recourse to the trust fund. And also, of course, there were complicated issues about the applicable law and so on, which were also something that preoccupied the court in that case. And if we regard that as simply background, that's fine, except that the Jersey Court of Appeal obviously didn't regard it as that, and Justice Appeal Logan Martin, it regarded himself, well, they all regarded themselves as bound by idea, even though there's a very strong judgment by the bailiff, making it pretty plain that he would have dissented from the majority, the court actually ended in unanimous finding because of the best second denial. The indication there is that he would have dissented from that on the strong grounds that Jersey customary law just didn't recognise hypothetically of immovable property. But he felt bound by that sentence effectively. So it is an important sentence. One can't just write it off as being something that's just said in past.
If it matters for the purpose of your submissions, you may have to look quite closely at whether or not that was part of the ratio. And the factual substructure was that the creditor claims which were sought to be enforced directly, and the right to do so having been upheld by the Guernsey Court of Appeal, I think, were debts incurred by persons who had ceased to be trustees at the material time. So it was certainly, it mattered to the board to understand by what route other than a direct claim the relevant third-party creditors in that case could have proceeded in a way that got them access to the trust fund.
Yes. Yes, I take your lordship point there.
I'm not expressing any view about whether it was or wasn't part of the ratio, but I think that underlying substratum of fact in that case needs to be borne in mind on any analysis of whether there is a ratio here on this particular point or not.
Yes, yes, certainly. I accept that caution. It's very difficult say very clearly one way or the other. The point of the present purpose is that plainly the Jersey Court of Appeal felt bound by that.
Yes. Putting it at its lowest, we simply decided that the creditors, that the BVI companies didn't have a direct claim.
Yes.
But we were, in a sense, saying, well, did they have a direct claim or some other claim? And if so, what was the other claim? And I think that may be where the prospect of being able to be subrogated to a non-possessory equitable lien came in. One might think that's what those who amended the Guernsey trust law thereafter also thought.
Well,
but that's a matter on which no doubt you'll make submissions.
Yes, well, the Guernsey trust law had been amended long before Investec into that one.
Oh, had it? I thought it was done to
2007, 2008.
You may be right, but
yeah, I'll find that the
yeah,
we've got a copy of the Jersey statute in the bundle.
We have indeed. I had a quick look. It's at page 2402 in the Guernsey bundle.
Okay. I'll find it in the.
I haven't been through the summary of the argument in the case in the court, but if the position is that the board was not addressed on relevant aspects of the customary law of Jersey, then you might be able to say that the remarks in paragraph 59 were made per incuriam.
Per incuriam, yes, I think that might be the better approach.
For what it's worth, I don't recall any submission about Guernsey, about Jersey customary law getting in the way of that proposition, but I don't pretend that my memory of a very complicated case is comprehensive.
No, but if one looks at the authorities that were cited, they were few and far between on
that point.
Yes. Yes. So I think really looking at it as a possible per incuriam point is better approach, respectively.
Yes.
Yes, the Guernsey law is at page 3944 of the Jersey bundle. And that was 2008. Yes, well, it's the Trust Guernsey Law 2007, 2008 print, and it's Article 44 of on the following page, 3945. Trustees lien for the purpose of securing a trustee's right to pay for the trust from the trust property and to be reimbursed from the trust property for all expenses and liabilities properly incurred and so on. The trustee is entitled to a non-possessory lien over the trust property in respect of all such expenses and liability, without prejudice to any indemnity or other security to which the trustee is entitled, which is odd in itself. And then the lien attaches to any trust property unless it's expressly waived or released, or it's no longer identifiable, or it's in the hands of a bona fide purchaser, or it's real property. And then at 5, it attempts to explain what the lien is. And it says the lien granted under subsection 1 is the right of the trustee, where he is not exonerated or reimbursed from the trust property, to follow, recover, and appropriate the trust property for purposes of realization, payment, and reimbursement. So it goes very far, that provision. It's difficult to see quite how the right of appropriation can sit really with the prospect of the fund being in somebody else's hands. Obviously, its powers over the trust fund have gone. Its trust law powers under the trust fund have gone. So it would need the assistance of the court. It's a cooperative trustee to satisfy that interest. But it's yes. So it's been there in the Guernsey law since that time. So it wasn't Investec that influenced that. Now, the judgments below, first of all, when in fact there are two judgments for the Commissioner, two separate issues, or two related issues, but separate judgments, and then of course there's the Court of Appeal judgment. And again, Stanley is going to take you to specific passages in those judgments. I don't want to take up too much time by duplicating or repeating what's said below, but the approach of the two courts was strikingly different. The Commissioner's judgments, they're at pages 211. First one is 211 to 261 of the main judgment. Second one is at 264 to 269. The main judgment shows a flexibility of approach, which the Court of Appeal did not show, saying that Justice of Appeal Logan Martin regarded these as fixed rights. He was bound by Investor Nala, and he was bound by other cases, which drove him to a fixed and rigid view of what the rights were. There was no concept of flexibility, doing fairness, balancing up creditors, or anything of that kind, which is evident in the Commissioner's judgment. They're two quite different approaches. The approach of Justice of Appeal Logan Martin was really to refer to certain authorities and say that they established certain things, and that he was bound by them, including in particular the case of Lemery, which figures considerably in this case. Lemery, which Stanley will deal with, was a first instance Australian decision, an extemporary judgment by a first instance judge, as Justice Haywardley in the Bermuda Court of the case of Meritus and Butterfield pointed out, not in any critical way, but simply pointed out that perhaps the authority was at that level, but Justice of Appeal Logan Martin placed a good deal of reliance on that case in his judgment. It's doing an awful lot of work, Lemery, in that judgment, and so it does need to be looked at rather carefully of other decisions. The significant judgment for our purposes, obviously, the Justice of Appeal Logan Martin's is the judgment of the court as it turned out, but the Commissioner's judgment repaid consideration. If I could take you to the Commissioner's, so the bailiff's judgment, I'm sorry, in the Jersey Court of Appeal.
I think it's round about 439.
It's at
Yes, begins at 439.
yes. So it was the bailiff's judgment in the Court of Appeal that I was.
439.
439. Yes, I'm sorry. He explains in paragraph 251, that's the bottom of page 439, that he completely understands why, given the present state of authorities, in particular the decision of the Judicial Committee in Investec, that Mr. Appeal Logan Martin reached the conclusion that he had, and he says, indeed, the hierarchy of courts requires me as a judge to accept that I am in practice bound by the decision in Investec, even though our Norman and civil law roots do not suggest that there is a binding system of precedent in this in England and Wales. This, of course, was on an appeal. As I said, the Investec decision was an appeal in the Guernsey case, not a Z Trust case. Accordingly, I do not formally dissent from the judgment which he just delivered, because I accept the logic of this analysis. Once one has accepted that the Investec decision is a starting point, so start from Investec. Nevertheless, he wanted to make some observation, and he deals some of the history in paragraphs 254 about the recognition of trust in Jersey. I'll skip over time. But in paragraph 257, page 442, he refers to the very well-known case of Rahman in Jersey, the trust case. One of the issues was whether or not terms of settlement made by the deceased husband plaintiff avoid breach of the Jersey rule that done in a word, a rule which applied to gift. Plaintiff contended therefore applied to gift into trust law. One of the arguments relied upon by the defendants was in the matter of trust, courts of Jersey until the Trust Court Act imported a whole system of law from England. Equity and equitable principles stood apart and took nothing from customary law. It was accordingly submitted that the court should not extract from customary law rules such as donne originally in a verb, one time and in some form or another apply part of customary law, and then apply it to trusts which were unknown to. And then he quotes from the Deputy Bailiff judgment in that the court was not persuaded by those arguments. Now, beyond question that the court is a court of equity, in many cases applies equitable remedies, but the court does not refuse to enforce or apply well-established customary law rules and principles. Hasn't overturned another concept, will not grant specific performance, but will compensate for damages reached from our heritage, and so on. 259, I do not share the view that there is the distinction to be made, as my brother Justice Appeal John Martin suggests, paragraph 284 below, 285 below. That is a distinction which Justice Appeal John Martin made, but he said effectively that justifies gifts into trust, not the incident trustship once the trust is established. But the bailiff says, in my view, if the customary law operates to strike down a gift into trust, there's no reason why it should not strike down the rights arising from a gift into trust. The greater includes the lesser. Indeed, Article 12(2)(a)(2) of the Trust Law, I took the panel, which provides that a trust is invalid to the extent that it purports to confer any right or power or impose any obligation, the exercise or carrying out of it, contrary to the law of Jersey, would seem to take one to the same conclusion. He does attribute us some importance to that provision. This approach to interrelationship with customary law, though not specifically referred to, is endorsed by the Privy Council in Investec. Quote the paragraph from Lord Hodge in 57 that I showed to you. This reservation that the English law of trust has not been imported wholesale into Jersey, but must be received subject to any statutory or customary law principles to the contrary, is an important reservation which may well in normal circumstances have an impact not only on the reasoning in the Investec case, but also on the decision in the present case. Paragraph 58 of the Privy Council judgment in Investec, that lordships indicated that while the trust law is the principal indigenous source of trust law, it is not a complete code for trust. Said that the statute gives statutory effects to some principles already established in England and significantly modifies other principles. Thus, it said that the English trust law says the background against which the provisions of the trust law may afford to be construed. There's no doubt, he says in paragraph 263, that English trust law does provide answers to many of the questions arisen in practice, but nonetheless, the reservations being mentioned do mean that practitioners exercise caution in simply assuming that English trust law will be the same as Jersey trust law. And he cites the allows the court to set aside gifts into trust on grounds of mistake. The Hastings Bass jurisdiction cases in point. Now I'm very conscious that we've at 1 o'clock, or perhaps a little bit past 1 o'clock. I do want to look a little bit more at the
Yes.
judgment, but may I perhaps say that until after the short agenda?
Yes, I think we haven't really embarked yet on the critical passages. So
No.
we can look forward to doing that at 2 o'clock.
Grateful to you all.
Thank you.